cases like, Hamilton against Dillon and so forth, and that history is, I think, set forth in Professor Baumsei's amicus brief.
Counsel, some time ago you dismissed the applicability of the major questions doctrine, and I want you to explain that a little bit more. I mean, it seems that it might be directly applicable. You have a claim source, an IEPA, that had never before been used to justify tariffs. No one has argued that it does until this particular case. Congress uses tariffs in other provisions, but not here, and yet, and correct me on this if I'm not right about it, the justification is being used for a power to impose tariffs on any product from any country in any amount for any length of time. That seems like, I'm not suggesting it's not there, but it does seem like that's major authority, and the basis for the claim seems to be a misfit. So why doesn't it apply again?
Well, we agree that it's a major power, but it's in the context of a statute that is explicitly conferring major powers, that the point of the statute is to confer major powers to address major questions, which are emergencies. So it'd be unusual to say, look at the statute and say, we're not going to find a major power here.
Well, but the exercise of the power is to impose tariffs, right? And the statute doesn't use the word tariffs.
But it uses the word regulate importation. And historically, a core central application of that, a big piece of that, has always been to tariff. If you had asked the founders, how do you regulate imports? They would say, of course, we tariff. That's what we do. So it'd be very unusual to say, we're giving you power to regulate importation, and say, but you cannot impose regulatory tariffs. That'd be almost a contradiction. And all the historical sources we cite in our brief, relate to that particular historical pedigree. And as I was referring to earlier, there's a specific pedigree of regulated importation here in the specific context of the presidents Polk and Lincoln and President McKinley asserting the authority to impose tariffs in wartime. That was then codified in TWIA and then recodified for peacetime in TWIA in 1933 and then carried over into IEPA. So there's that as well. But more importantly, if you look at the sort of triggering conditions that members of this court have identified for the major questions doctrine, there's a series of them, and we think they really do, all of them don't apply here. For example, the notion that the power is unheralded. You referred to the fact that IEPA has never been asserted to invoke tariffs, but of course, the immediately predecessor statute, the tariffs that President Nixon imposed on that were upheld under this very language. So this, I would say this is, and it was recodified in IEPA 2 years later. So this is kind of the opposite of unheralded power. It's also heralded because there's this long-standing delegation, a tradition of very broad delegations of the foreign commerce power going back to the founding, going back to—
Well, yeah, foreign commerce part, but I mean, and I think this is a question for the other side as well. It's two-facing. Yes, of course, tariffs and dealings with foreign powers, but the vehicle is imposition of taxes on Americans, and that has always been the core power of Congress. So to have the president's foreign affairs power trump that basic power for Congress seems to me to kind of at least neutralize between the two powers, the executive power and the legislative power.
Let me say two things in response to that. First, the notion that the taxes are all borne by Americans and are not borne by foreign producers whose goods are imported is empirically, there's no basis for that in the record. It's actually a mixed—
Well, who pays the tariffs? If a tariff is imposed on automobiles, who pays them?
Typically there'd be regardless of who the importer of record is, there'd be a contract that would go along the sort of line of transfer that would allocate the tariff, and there'd be different, sometimes the foreign producer would pay them, sometimes the importer would bear the cost. The importer could be an American, could be a foreign company. A lot of times it's a wholly owned American subsidiary of a foreign corporation. So it gets allocated. The empirical estimates range from like 30% to 80% of like how much is borne by American
it's
citizens.
been suggested that the tariffs are responsible for significant reduction in our deficit. I would say that's raising revenue domestically.
There certainly is an incidental and collateral effect of the tariffs that they do raise revenue, but it's very important that they are regulatory tariffs, not revenue-raising tariffs. And the way you can see this, I think, if you look at this policy is by far the most effective if nobody ever pays the tariffs. And I say two policies, right? So if you look at the trade deficit emergency, if nobody ever pays the tariffs and instead Americans direct their consumption towards American producers and stimulate the rebuilding of our hollowed out manufacturing base, then the policy is by far the most effective. So a tariff, a regulatory tariff that—
Why not do what the statute permits? Bar importation of products altogether. That would be the most effective way to do it.
What the question
You
is whether
follow
this-
the statute. The statute says the president can do that. What it doesn't say is the president can raise revenue.
What it says, he can regulate importation and going back for
Regulated
hundreds of
by
years, the way you regulate importation is
quotas,
a tariff.
causing it, subjecting some countries and not others to importation bans. There's a lot of verbs, but none of them include generating revenue as a side effect or directly.
Let me address that verb point, if I may, because think about the canonical example, a statute that refers to a list of swords, knives, daggers, dirks, and pikes. There you look at that list of things and you say, aha, those are all weapons, therefore a pike is a spear, not a fish in that particular context. Now look at this list of verbs, block, prohibit, compel, direct, and so forth. You don't look at that naturally as an ordinary reader and say, oh, look, they're all not revenue raising. What you say is they're all very broad, powerful, actions that you can
General,
take.
the verbs that are in the statute are actually doing something. I mean, they're in the statute for a reason, and as I understand it, Congress actually explained to us in its Senate report and House report when it enacted the 1941 amendments to TWIA, what it was doing. It said that what we are doing is authorizing the president, in the Senate report, quote, to control or freeze property transactions where a foreign interest is involved. There's similar language about controlling, freezing control in the House report. So I appreciate that generally you can look at these words and you can imagine that they mean certain things, but here we have evidence that Congress was actually trying to do a particular thing with respect to the authority that it was presenting to the president, and that thing was not raising revenue.
I think that the powers that Congress was conferring on the president are best understood through the plain text of the statutes, which includes regulating
No, I
importation.
know, but some of us care about the legislative history. And so the plain text of the statute has certain verbs in it. It also has regulate commerce, as you say. And when I look at the legislative history, it appears as though Congress was trying to give the president the authority to, quote, control or freeze property transactions where a foreign interest is involved. And in the TWIA context, that makes perfect sense because we're talking about a wartime dynamic. And what is happening is the president needs the authority to prevent trading with the enemy in the midst of a war. And that seems to be the focus of this statute. So I guess I'm concerned about just sort of taking a particular word here and there and saying that the general view of it might include raising revenue when in fact it looks as though the aim of this was really to give the president a certain kind of authority to freeze the assets of the enemy.
And let me say two things in response to that. First, as the notion that this is a revenue-raising tactic or power, it is not. We are asserting a regulatory power. It's a delegation of the power to regulate foreign commerce. The way to control imports traditionally has been to tariff them. They say, well, you can impose quotas. Well, quotas are essentially economically equivalent to tariffs. So the question is, why would you be able to quota under regulate but not tariff under regulate when the tariffs are themselves regulatory? And let me turn back to the question the response I was giving
Could
to
the
Chief
answer be,
Justice to illustrate
could
that.
the answer be that in other places where Congress wants that particular form of regulation to be used, they say impose duties. They say you can tax, Mr. President. Here they don't say that.
I'd say two things in response to that. That's the very argument that this court rejected in Algonquin, that the fact that these other specific statutes
If we
do
disagree
you
with
say
you
it a certain
about,
way, you have to do
if we
it this
disagree
way.
with you that Algonquin is a similar context, do you have another statute or another circumstance?
And again, not to cite Algonquin again, but obviously
Yes.
we discussed the phrase adjust imports. And they said, no, the natural way to do that is to tariff them. And it specifically said it makes no sense at all to authorize quotas, which was conceded that statute did authorize, but not tariffs, because those are equivalent.
But
And
it
we have
said
exactly the same
adjust
position
by
here.
any means necessary, which kind of beefs up the adjust. And also, and this is actually, I just don't know the answer to this question, so maybe you can help and maybe the other side can help as well. Algonquin was very careful to always call it a license and a licensing fee, and in the oral argument that came up too, the distinction between a tariff and a licensing fee. And I can understand how in some contexts it would be very difficult. You would press on it and you would say, well, if this license fee is raising revenue, then it actually functions as a tariff. But what is the significance of that? Because in IEPA, it also says, it refers particularly to licenses. It says you can license, and license would be a way of giving permission. That's actually the language also used in the Civil War one, and what is it?
Hamilton against Dillon,
Yeah.
exactly, yes, it does.
It was a license fee, and that's a way to grant permission that you wouldn't otherwise have to trade and import and let it through. So tell me what the distinction is between licenses and fees and if it matters.
It's hard for me to see one, because what President Lincoln said is, okay, we're going to allow imports from hostile foreign powers, basically rebellious Confederate states, of cotton subject to a license, but you got to pay 4 cents a pound on cotton. When you do it, that's the condition. That is so nearly equivalent to a tariff that says you can bring these goods into our country, but you got to pay a ad valorem assessment on it. And so, and of course, they have in their briefs conceded that quotas apply, that licensing may apply. There is the language in the beginning of 1701 that talks about instruments, or other methods, instruments, licenses.
But if that were true, why couldn't you just call this a license? And it's also true that in the cotton example, the court said the exaction itself was not properly a tax, but a bonus required as a condition precedent for engaging in the trade. So it seems like it was a little squirrely about how it was proceeding. And if there really is no distinction, why couldn't you just call it a license here?
Very briefly, the other two cases, the Polk case and then the President McKinley case, talk about duties. So I see an equivalence there, Mr. Chief Justice.
Thank you, counsel. Justice Thomas, anything further?
The other side is going to make an argue on delegation, I believe. Would you anticipate that and give us your understanding of the delegation argument?
Yes, Justice Thomas, I'd say a couple things in response to that. First of all, this court has stated that the non-delegation doctrine does not apply with anything like the same force as it does in the domestic context in the foreign context. And that, again, to cite Dames and Moore again, Dames and Moore cites Youngstown, and Youngstown in footnote 2 of Justice Jackson's opinion, he goes into detail about this. He addresses Curtis Wright. He says there's a lot of broad dicta in Curtis Wright, but the holding of Curtis Wright, the ratio dissidenti, is that the domestic non-delegation doctrine does not apply with the same force in the foreign context. And then he uses that phrase, does not apply. He says the strict limitations on delegation that apply, in the internal context do not apply in the external context. And so we rely on that line of cases. And for the reasons I talked about earlier, where we're talking about a situation where the president has his own inherent authority to address foreign arising emergencies, and Congress is conferring tools on him that expand his ability, his capacity to do so, we are in the area of Youngstown Zone 1.
A few times you have alluded to the history as being important in interpreting the statute, and also that this language comes from the Trading with the Enemies Act, and that has its own pedigree. Could you just sketch out this direct line that you were alluding to as a basis for interpreting the current emergency statute as you would like it interpreted?
Yes, Justice Thomas, and turning back to the response I was giving to Justice Barrett earlier, there is, I think it's very well set out in Professor Baumsei's amicus brief, there is this history of presidents using a tariffing power or a tariff equivalent power, very, very close to tariffing power, in wartime to tariff trading with enemies. And that is when the Trading with the Enemy Act was enacted in 1917, it was deliberately evoking that. And when it brings in the power to regulate importation, it's essentially codifying for an inherent power the president's already recognized to have. And then in 1933, when that power is expanded to an area where he wouldn't inherently have it, the peacetime context, that codification, the meaning of that remains the same. The regulate importation language that's brought in from TWIA and then ultimately to IEPA in 1977 is carrying with it that connotation, and that's reinforced by all the cases we've cited in our brief where there's been extremely broad delegations of the power to tariff specifically and the power to regulate foreign commerce more generally, going back to the time of the founding, which ties to your question about non-delegation.
Justice Alito?
The court of the CCPA said things in Yoshida that are helpful to your position, but it also said some other things. It said that future surcharges, quote, must of course comply with Section 122 of the Trade Act of 1974, and it said that the Trading with the Enemy Act did not authorize the president to, quote, fix rates of duty at will without regard to statutory rates prescribed by Congress. So do you think that Congress To the extent Congress had that decision in mind and relied on it, do you think it also relied on those statements in the opinion?
Not in the same way, because those statements are read into other provisions of TWIA that Congress did not enact in a NEPA. They may still be there in TWIA, but those are limitations that it wouldn't make sense to do. And I think the significance of Yoshida is at a higher level. Keep in mind that their principal position is no tariffs at all. Regulated importation just doesn't carry a connotation of the power to tariff. And we say we've got historical sources going back to Gibbons against Ogden that say the opposite. But more fundamentally, everyone knew that at the time IEEPA was enacted that regulated importation had just very visibly and very prominently been upheld to include a sweeping global tariff.
Thank you.
Mrs. Sotomayor?
I'd like to go back to Justice Barrett's question on the word license as used in IEEPA. It's not used as a verb, it's used as a noun. By the President may, under such regulations as he may prescribe, by means of instructions, licenses, or otherwise, then do what the verbs permit him to do. By license, he can nullify, void, prevent, or prohibit any acquisition, etc. So license is not being used as a verb that through licensing he can raise revenue. He can only use licenses to accomplish the verbs. So I don't understand how we can treat licensing as equivalent to revenue raising. As used in IEEPA, the license is only to accomplish what B permits.
In Hamilton against Dillon, licenses, once you had the license, then you had to pay the fees, the license fees to get it in, and those are
But that's the point I'm making, which is that the only use of license here is a noun. You can license to accomplish the powers that B gives the president.
Let me be clear, we rely on the phrase regulate importation. We're not saying that
Exactly.
executive
You're
orders
not
are
relying on
licensed.
licenses for that reason.
No, I only cite that language, that introductory language about, instruments, licenses,
That
or
you can't
otherwise
rely on
as
revenue.
another layer of breadth in this particular
Counsel, would you listen to my question? You're not relying on license for the reason I just said, because it is a noun, not the verb. You're relying on regulate, correct?
Yes, we're relying on regulate importation.
And despite the fact that no other president in the history of IEEPA has ever used tariffs as a power under IEEPA.
Well, President Nixon did so
Under a predecessor, and we have all the limitations of that. All right. Number two, whenever Congress intends to permit taxing and regulate, it uses the word tax and regulate in every other statute, correct?
I don't concede that. I mean, two very visible examples, again, are TWIA and Section 122.
We're back to the question here. Okay, thank you, Counsel.
Justice Sotomayor?
No, she's Justice Sotomayor. She just finished.
Justice Kagan?
General
And
Sa-
they're friends?
I want to take you back to Justice Thomas's question about non-delegation, and if I understood your answer correctly, it was really similar to the answer that you started off with when you talked with Justice Thomas about the major questions doctrine, which is sort of everything's different because the president has independent constitutional powers in this area. And so that if one does not think that with respect to tariffs, if one thinks that a tariff is a taxing power, is a regulation of foreign commerce that is really delegated by the Constitution to Congress, that argument does not sound so well. And in fact, when you look at J.W. Hampton, which gives rise to the non-delegation test that we usually use, J.W. Hampton is a tariffs case. And the court did not say, oh, we need some special new principle here, some stricter rule because we're dealing with tariffs in which presidents are directly concerned as a matter of foreign relations. It enunciated the test we use for all non-delegations. So how does that fit with your theory?
8 years later, in Curtis Wright, the court held the non-delegation doctrine for domestic affairs does not apply with the same force as it does in
But
foreign
not with
affairs.
respect to tariffs, not with respect to quintessential taxing powers, which are given by the Constitution to Congress.
I think justices of this court have recognized in their opinions that one of the reasons that the non-delegation doctrine that intelligible principle test hasn't packed as much punch as Justice Kavanaugh said in one of his opinions as it might otherwise have done, is it did arise in the foreign affairs context, because there the court has historically been very, very comfortable with very broad delegations. Chicago and Southern Airlines, another case from the 1930s, shortly after J.W. Hampton talked about being very large delegations of the foreign commerce power being very effective. And of course, this goes back to the very dawn of the Republic in 1790, for example. Congress conferred on President Washington basically the entire Indian commerce power. It said, go, get licenses, right, to do commerce with the Indians, and they'll be subject to whatever rules and regulations President Washington can make. So I do think there is a profound consistency between the announcement of the intelligible principle test in J.W. Hampton and then the subsequent recognition by this court in Curtis Wright that the non-delegation doctrine doesn't apply with the same force in this context.
In consumers research just last year, we had a tax before us, and the question was this a delegation issue? It was, of course, a much smaller tax, which dealt with many fewer taxpayers. Notwithstanding that, we said if there's no ceiling on this tax, we sort of assumed that if there were no ceiling on this tax, it would raise a delegation problem. And the